Philippine Political Law by Cruz, 2022 edition. The Constitution declares rather superfluously that the state may not be sued without its consent. This provision is merely a recognition of the sovereign character of the state and an express affirmation of the unwritten rule insulating it from the jurisdiction of the courts of justice. Accordingly, it has been recognized that the rule that a state may not be sued without its consent is one of the generally accepted principles of international law that we have adopted as part of the law of our land under Article 2, Section 2. Basis. It is obvious that indiscriminate suits against the state will result in the impairment of its dignity, besides being a challenge to its supposed infallibility to Justice Holmes. However, the doctrine of non-suability is based not on any formal conception or obsolete theory, but on the logical and practical ground that there can be no legal right against the authority which makes the law on which the right depends. Another justification is the practical consideration that the demands and inconveniences of litigation will divert the time and resources of the state from the more pressing matters demanding its attention, to the prejudice of the public welfare. The doctrine is also available to foreign states insofar as they are sought to be sued in the courts of the local state. The added basis in this case is the principle of the sovereign equality of states under which one state cannot assert jurisdiction over another in violation of the maxim par in parem non habet imperium. To do so would unduly vex the peace of nations. This does not mean, though, that the foreign state would at all times be immune from all suits filed against it before courts of a host or local state. Accordingly, it has been ruled that such foreign states may be sued in the host state if engaged regularly therein in a business or trade, or even if not so, engaged on the basis of its contracts in the host state, which may be considered as purely commercial, private, and proprietary acts, but not with respect to its contracts entered into by it as governmental or sovereign acts. Thus, the doctrine of state immunity from suit has undergone further metamorphosis. The view evolved from the existence of a contract does not per se mean that sovereign states may at all times be sued in local courts. The complexity of relationships within sovereign states brought about by their increasing commercial activities mothered a more restrictive application of the doctrine. As it stands now, the application of the doctrine of immunity from suit has been restricted to sovereign or governmental activities. Acts jure imperii, the mantle of state immunity, cannot be extended to commercial, private, and proprietary acts, iuris junis. In other words, the fact that a foreign state enters into a contract with a private party in the host state would not necessarily result in the waiver of its sovereign immunity. The character of said contract would still need to be determined such that said foreign state may be sued if its contract were commercial in nature. This precept was reiterated in Association of Medical Clinics for Overseas Workers (INC) versus GCC approved Medical Centers Association (INC), where the Supreme Court stressed that the recognition of sovereign immunity, however, has never been unqualified. While we recognized the principles of independence and equality of states to justify a state's sovereign immunity from suit, we also restricted state immunity to acts jure imperii, or public acts, We said that once a state enters into commercial transactions, use cronies, then it descends to the level of a private individual and is thus not immune from the resulting liability and consequences of its actions. In said case, the court explained that while it can be recognized that a foreign government acting in its jus imperii function cannot be held liable in a Philippine court, this recognition is altogether different from exempting governments whose agents are in the Philippines from complying with our domestic laws. We have yet to declare in a case that the principle of sovereign independence and equality exempts agents of foreign governments from compliance with the application of Philippine domestic law. It is significant that in this case the court stressed that the respondent had not adduced any evidence nor has it presented any argument showing that the principle of sovereign equality and independence has developed into an international custom shielding state agents from compliance with another state's domestic laws. Under this situation, the court is in no position to determine whether the practice that GAMCA alleges has indeed crystallized into an international custom. As will be discussed later, in the context of the applicability of the principle of state immunity to a state in relation to claims filed against it by its citizens or inhabitants or in connection with the actions of its government within its territory, not all acts juri imperii may exempt a state from suit, as in the case of its exercise of its power of eminent domain when done without payment of just compensation. Moreover, it has likewise been ruled that not any agency of a foreign state may properly invoke the latter's sovereign immunity to ward off suits against it. In German Agency for Technical Cooperation versus Court of Appeals, the petitioner moved to dismiss a complaint for illegal dismissal filed against it before the National Labor Relations Commission, contending that the labor arbiter had no jurisdiction over it. Dismissed complaint for illegal dismissal filed against it before the National Labor Relations Commission, contending that the labor arbiter had no jurisdiction over it, as it was the implementing agency of the government of the Federal Republic of Germany. And its acts were undertaken in the discharge of the governmental functions and sovereign acts of the government of the Federal Republic of Germany. The Supreme Court rejected these contentions, stating that the petitioner did not present adequate evidence to establish that it enjoys the immunity from suit generally accorded to its parent country, the Federal Republic of Germany, adding that assuming that characterization is correct, it does not automatically invest GTZ with the ability to invoke state immunity from suit. In China National Machinery and Equipment Corporation versus Santa Maria, the petitioner designated by the Republic of China as its prime contractor for the North Rail project of the Republic of the Philippines as certified by its Chinese ambassador claimed sovereign immunity in connection with the suit against it based on its memorandum of understanding with the North Luzon Railways Corporation. The Supreme Court rejected its claim, applying its earlier ruling in the German Agency for Technical Cooperation case, and stressed that even if the petitioner contends that it performs governmental functions, its designation as the primary contractor does not automatically grant it immunity, just as the term implementing agency has no precise definition for purposes of ascertaining whether GTZ was immune from suit, although CNMEG CNMEG claims to be a government-owned corporation. It failed to adduce evidence that it has not consented to be sued under Chinese law. Thus, following this court's ruling in Dush Gesellschafts, in the absence of evidence to the contrary, CNMEG is to be presumed to be a government-owned and controlled corporation without an original charter. As a result, it has the capacity to sue and be sued under Section 36 of the Corporation Code. Application. Actions are rarely instituted directly against the Republic of the Philippines, presumably because such a step will provoke resort to the doctrine of state immunity and possible dismissal of the complaint for lack of jurisdiction. The usual practice is to file such claims not against the state itself, but so as to avoid the appearance of its involvement against the officer of the government who is supposed to discharge the responsibility or grant the redress demanded. It is important then to determine if the state is the real party in interest. That is, that the claim, if proved, will be a direct liability of the state and not merely of the officer impleaded. If this is shown, the action can be dismissed as a suit against the state unless its immunity had been previously waived. To illustrate, it was held in one case that a claim for damages for injuries sustained by the plaintiff while undergoing military training as required by law was actually a suit against the state since it would need the appropriation of public funds to satisfy the judgment if the claim were allowed. Although filed against the Chief of Staff of the Armed Forces of the Philippines, in his official capacity, it was dismissed because the state had not waived its immunity. In Sanders versus Veridiano, where two American employees of the Subic Naval Base sued its commanding general and the director of his special services for damages for allegedly defamatory remarks made by the defendants. The Supreme Court held petitioners were being sued as officers of the United States government, as they have acted on behalf of that government and within the scope of their authority. It is that government and not the petitioners personally that is responsible for their acts, assuming that the trial can proceed and it is proved that claimants have a right to the payment of damages. Such award will have to be satisfied not by the petitioners in their personal capacity, but by the United States government as their principal. This will require the government to perform an affirmative act to satisfy the judgment, viz. The appropriation of the necessary amount to cover the damages awarded, thus making the action a suit against that government without its consent. In University of the Philippines versus Dizon, the Supreme Court stated that an award against the petitioner for moral and actual damages, including attorney's fees, would require an appropriation by Congress considering that such monetary liabilities were not covered by the appropriations earmarked for said project, which was the subject of the suit and the consequent award. Indeed, the court explained in Rallios versus Ingles that even if there were appropriations for such money awards, the courts are nevertheless directed to proceed with extreme prudence in satisfying judgments involving public funds against government agencies and local government units, and cannot indiscriminately issue writs of execution against the government to enforce money judgments. At any rate, the court explained in Confederation of Coconut Farmers of the Philippines INC versus Aquino that the matter of the release of coconut levy assets which have been judicially declared with finality as public funds need not necessarily be the subject of a writ of execution. As such, a writ was never meant to be a prerequisite before a judgment may be enforced. It said that upon such declaration of said assets as public funds, the government may take the necessary steps to preserve them and to be able to utilize them. It does not deprive the courts with its power to issue writs of execution because the government may resort to it in case it encounters obstacles in the enforcement of the decision. By contrast, the Supreme Court held as not against the state an action instituted against the Secretary of National Defense, also in his official capacity, for payment of an architect's professional fees for which an appropriation had already been made by the government. The reason was that, as far as the state itself was concerned, It had already discharged its obligation clearly. That the complaint wanted only was the actual payment of the amount already set aside, which payment was now the sole responsibility of the defendant. The action was therefore properly filed against him only and not against the state, and no waiver of its immunity was necessary. There are many instances, in fact, when a public officer may be sued in his official capacity without the necessity of first obtaining the consent of the state to be sued. Thus, a public officer may be impleaded to require him to do a duty required by law or to restrain him from doing an act alleged to be unconstitutional or illegal, or to recover from him taxes unlawfully assessed or collected. Houston versus Hormes. It has also been held that where an action is filed against a public officer for recovery only of title or possession of property, title or possession of property, claimed to be held by him in his official capacity, said action is not a suit against the state for which prior waiver of immunity is required, but it is different where there is in addition a claim for recovery of damages such as accrued rentals inasmuch as its allowance would require the government to appropriate the necessary amount for the satisfaction of the judgment. Sigia versus Almeida. In sum, the test is whether, assuming the decision is rendered against the public officer, impeded enforcement thereof will require an affirmative act from the state, such as the appropriation of the needed amount to satisfy the judgment. If it does, the suit is one against the state and its inclusion as party defendant is necessary. If, on the other hand, the officer impleaded may by himself alone comply with the decision of the court without the necessity of involving the state, then the suit can prosper against him and will not be considered a claim against the state. It is understood, of course, that where a public officer acts without or in excess of jurisdiction, any injury caused by him is his own personal liability and cannot be imputed to the state. Thus, in Festejo versus Fernando, the director of public works took over, without authority, property belonging to the plaintiff and constructed thereon a public irrigation canal. The Supreme Court held that the action for the recovery of the land or its value was properly filed against the defendant in his personal capacity and was therefore not covered by the doctrine of state immunity. In USA versus Ginto, the Supreme Court declared that the other petitioners in the cases before us all aver they have acted in the discharge of their official functions as officers or agents of the United States. However, this is a matter of evidence. The charges against them may not be summarily dismissed on their mere assertion that their acts are imputable to the United States of America, which has not given its consent to be sued. In fact, the defendants are sought to be held answerable for personal torts in which the United States itself is not involved. If found liable, they and they alone must satisfy judgment. But even as we are certain that the individual petitioners in GR number 818 were acting in the discharge of their official functions, we hesitate to make the same conclusion in GR number 80258. Contradictory factual allegations in this case deserve, in our view, a closer study of what actually happened to the plaintiffs. The record is too meager to indicate if the defendants were really discharging their official duties or had actually exceeded their authority when the incident in question occurred. Lacking this information, the court cannot directly decide this case. The needed inquiry must first be made by the lower court so it may assess and resolve the conflicting claims of the parties on the basis of the evidence that has yet to be presented at the trial. Only after it shall have determined in what capacity the petitioners were acting at the time of the incident in question will this court determine, if still necessary, if the doctrine of state immunity is applicable. In the case of the Holy See versus Rosario, the Supreme Court dismissed a civil complaint against the petitioner after the Department of Foreign Affairs had officially certified that the Embassy of the Holy See is a duly accredited diplomatic mission to the Republic of the Philippines, exempt from local jurisdiction and entitled to all the rights, privileges, and immunities of a diplomatic mission or embassy in this country. It was further affirmed that the determination of the executive arm of the government that a state or instrumentality is entitled to a sovereign or diplomatic immunity is a political question. That is conclusive upon the courts. Where the plea of immunity is recognized and affirmed by the executive branch, it is the duty of the courts to accept this claim so as not to embarrass the executive arm of the government in conducting the country's foreign relations. Thus, in German Agency for Technical Cooperation versus Court of Appeals, the Supreme Court explained that an endorsement by the Office of the Solicitor General on the petitioner's claim of state immunity, manifested in its comment filed in connection with said proceedings, does not inspire the same degree of confidence as a certification from the DFA would have elicited. The Supreme Court, in further affirmation of this principle, rejected in China National Machinery and Equipment Corporation versus Santa Maria the executive endorsements of the certification executed by the Economic and Commercial Office of the Embassy of the People's Republic of China on the purported sovereign immunity of the petitioner, made by the Office of the Solicitor General and of the Office of the Government Corporate Counsel, clarifying that it is only the Department of Foreign Affairs which has the authority to make a determination of immunity from suit. Only the Department of Foreign which has the authority. Although in said case, the court declared that it would not be precluded from making an inquiry into the intrinsic correctness of such certification, waiver of immunity, although the doctrine of state immunity is sometimes called the royal prerogative of dishonesty, it must be observed in fairness that the state does not often avail itself of this rule to take undue advantage of parties that may have legitimate claims against it. The principle fortunately has a built-in qualification. The state may, if it so desires, divest itself of its sovereign immunity and thereby voluntarily open itself to suit. In fine, in fine, the state may be sued if it gives its consent. It is gratifying that the exception appears now to be general policy, with the result that the filing of suits against the state has become less difficult than before. Forms of consent. The consent of the state to be sued may be given expressly or impliedly. Express consent may be manifested either through a general law or a special law. The general law providing for the standing consent of the state to be sued is Act No. 3083, declaring that the government of the Philippine Islands hereby consents and submits to be sued upon any moneyed claim involving liability arising from contract, express or implied. which could serve as a basis of civil action between private parties. Under the CA number 327 as amended by PD number 1445, a claim against the government must first be filed with the Commission on an Audit. Indeed, it has been ruled that writs of execution issued by regular courts of justice in connection with money claims filed against the government may not be implemented without the same first being referred to the Commission on Audit. An example of the second kind of express consent is the special law enacted by the Philippine legislature authorizing an individual to sue the Philippine government for injuries he had sustained when his motorcycle collided with a government ambulance. It is significant that it has been ruled that an express waiver can also be provided for in a treaty, such as the Visiting Forces Agreement, but application only to suits covered by the same and may not be invoked as general consent for all suits. Thus, in Arrigo versus Swift, the reliance by the petitioner on such a waiver in the VFA in justification of his application for a writ of kalikasan was rejected by the court, stating that as it is, the waiver of state immunity under the VFA pertains only to criminal jurisdiction and not to special civil actions such as the present petition for issuance of a writ of kalikasan. The express consent of the state to be sued must be embodied in a duly enacted statute and may not be given by a mere counsel of the government, as held in Republic versus Purissima. In this case, the waiver made by the lawyer for the Rice and Corn Administration, an agency of the government, that was held by the Supreme Court as not binding upon the state. Incidentally, under Rule 14, Section 13 of the 1997 Rules of Procedure, where the defendant is the Republic of the Philippines, service of summons must be made on the Solicitor General. Worthy of note in this connection is the case of Amigable versus Cuenca, where the question raised was the right of the plaintiff to sue the government for recovery of the value of her property, which had been converted into public streets without payment to her of just compensation, although it was shown that she had not previously filed her claim with the Auditor General as normally required. The Supreme Court decided in her favor, reiterating the following pronouncement in the earlier case of Ministerio versus City of Cebu. If the constitutional mandate that the owner be compensated for property taken for public use were to be respected as it should, then a suit of this character should not be summarily dismissed. The doctrine of governmental immunity from suit cannot serve as an instrument for perpetrating an injustice on a citizen. Had the government followed the procedure indicated by the governing law at the time, a complaint would have been filed by it, and only upon payment of the compensation fixed by the judgment or after tender to the party entitled to such payment of the amount fixed, may it have the right to enter in and upon the land so condemned, to appropriate the same to the public use defined in the judgment. If there were an observance of procedural regularity, petitioners would not be in the said plaint they are now. It is unthinkable then that precisely because there was a failure to abide by what the law requires, the government would stand to benefit. It is just as important, if not more so, that there be fidelity to legal norms On the part of officialdom, the rule of law were to be maintained, it is not too much to say that when the government takes any property for public use, which is conditioned upon the payment of just compensation to be judicially ascertained, it makes manifest that it submits to the jurisdiction of a court. There is no thought then that the doctrine of immunity from suit could still be appropriately invoked. Similarly, in the Los Santos versus Intermediate Appellate Court, the Supreme Court reversed the trial court's dismissal on the ground of state immunity of a complaint for damages filed by the plaintiff on whose property was constructed by the government through the provincial engineer of Rizal an artificial creek without his knowledge or consent, declaring that the doctrine of sovereign immunity was not an instrument for perpetrating any injustice on a citizen. In exercising the right of eminent domain, the state exercises its jus imperii, as distinguished from its proprietary rights. Proprietary rights. Jus estionis. Yet even in that area where private property is to be taken in expropriation without just compensation being paid, the defense of immunity from suit cannot be set up by the state against an action for payment by the owners. As stressed by the Supreme Court in Republic versus Sandigan Bayan, the doctrine of sovereign immunity cannot be successfully invoked to defeat a valid claim for compensation arising from the taking without just compensation and without the proper expropriation proceedings being first resorted to of the plaintiff's property. In this case, the court ruled that when the Republic entered into a compromise agreement with a private person, it stripped itself of its immunity from suit and placed itself on the same level as its adversary. When the state enters into a contract which creates mutual or reciprocal rights and obligations, the state may be sued even without express consent. Its consent to be sued is implied from its entry into the contract, and the Republic's breach grants the other party the right to enforce or repudiate the contract. In Santiago versus Republic, the plaintiff sued the government for revocation of a donation on the ground of failure of the defendant to comply with the stipulated conditions. The defendant moved to dismiss for lack of its consent to be sued. The Supreme Court denied the motion, holding that the suit could prosper because it did not involve a money claim against the state, as what the plaintiff was seeking was the return only of the properties donated. He did not even need to file his claim first with the Commission on Audit under the provisions of CA number 327. This principle was reiterated in Republic versus Roque, where the court similarly ruled that the state's failure to abide by the conditions in a deed of sale constitutes its implied waiver of its immunity, and in Philippine Navy Golf Club ANC versus Abaya, where it declared that the Philippine Navy cannot invoke the doctrine of state immunity, considering that it has no valid reason to deprive Abaya et al. The enjoyment of the lands awarded to them. Moreover, the Philippine Navy fully utilized the lands for more than or less 20 years to generate income in violation of Abaya et al.'s property rights, manifestly based on equitable grounds. The rule that when the state itself files a complaint, the defendant is entitled to file a counterclaim against it. A case in point is Froilan versus Pan Oriental Shipping Company, where it was held that the government impliedly allowed itself to be sued when it filed a complaint in intervention for the purpose of ascertaining a claim for affirmative relief against the plaintiff to wit recovery of a vessel, but a similar conclusion was not reached in Ling versus Brownell, where the Philippine government, as successor in interest of the United States to the properties being claimed from the latter, filed a complaint in intervention to join the defendant in invoking the doctrine of state immunity to secure the dismissal of the action. That the Philippine government was not asking for any affirmative relief from the plaintiff but had intervened only for the purpose of resisting his claim, the Supreme Court held that no implied waiver of immunity could be assumed. This ruling was reiterated in the case of Republic versus Sandigan Bayan. Such as assumption is justified. However, When the government enters into a contract for the state is then deemed to have divested itself of the mantle of sovereign immunity and descended to the level of the ordinary individual. Having done so, it becomes subject to judicial action and processes. While the suggestion in Santos versus Santos and Leons versus United States of America was that immunity would be lost regardless of the nature of the contract, it was held in the case of United States of America versus Ruiz that suability would follow only if the contract is entered into by the government in its proprietary capacity. Governmental contracts do not result in implied waiver of the immunity of the state from suit. The private respondent in this case had claimed that the United States, through its engineering command in the U.S. Navy, had entered into a contract with it for the repair of wharves in Subic Bay and should therefore be required to comply with the agreement or pay damages. The United States moved to dismiss, invoking its non-suability, but the claim was denied by the lower court on the basis of the Leon's case. In this petition for certiorari, the Supreme Court sustained the immunity of the petitioner from suit, declaring through Justice Vicente Abad Santos that the traditional rule of state immunity exempts a state from being sued in the courts of another state without its consent or waiver. This rule is a necessary consequence of the principles of independence and equality of states. However, the rules of international law are not petrified. They are constantly developing and evolving, and because the activities of states have multiplied, it has been necessary to distinguish them between sovereign and governmental acts, jure imperii, and private, commercial, and proprietary acts, jure gestionis. The result is that state immunity now extends only to acts jure imperii. The restrictive application of state immunity is now the rule in the United States, the United Kingdom, and other states in Western Europe. The restrictive application of state immunity is proper only The restrictive application of state immunity is proper only when the proceedings arise out of commercial transactions of the foreign sovereign, its commercial activities or economic affairs. Stated differently, a state may be said to have descended to the level of an individual and can thus be deemed to have tacitly given its consent to be sued only when it enters into business contracts. It does not apply where the contract relates to the exercise of its sovereign functions. In this case, the projects are an integral part of the naval base which is devoted to the defense of both the United States and the Philippines, indisputably a function of the government of the highest order. They are not utilized for nor dedicated to commercial or business purposes. Accordingly, it was likewise ruled in Buisan versus Commission on Audit and Department of Public Works and Highways that, as the state's engineering and construction arm, the DPWH exercises governmental functions that effectively insulate it from any suit, much less from any monetary liability. Therefore, the failure to allege the existence of the state's consent to be sued in the complaint is a fatal defect, and on this basis alone should cause the dismissal of the complaint. On the other hand, it was held in the Ginto case that the operation by the United States government of restaurants in Camp John Hay in Baguio City and of barbershops in Clark Air Base, these establishments being open to the public for a fee, were proprietary in nature and so not covered by the doctrine of state immunity. An agreement to submit any dispute to arbitration may be construed as an implicit waiver of immunity from suit. Finally, it should also be observed that when the state gives its consent to be sued, it does not thereby also consent to the execution of the judgment against it.